Business law is a prerequisite for the student preparing for a career in business, accounting, government, or law. As you know, based on your brainstorm in your first discussion post, the basic knowledge of business law is important, right? Because the law is going to touch each of us at one time or another. Many of us know family members who have been through some sort of legal situation, or we all own cell phones, right? So we all have signed a contract before. Business law is just something that will provide some foundational knowledge moving forward through your career and also your life. This course is going to be focusing on getting a basic knowledge of fundamental legal principles. And really where this starts is in concepts. So you're going to be getting some practice in understanding the various legal concepts that form the foundation for the law. We'll also be developing logical reasoning as we work through some of our discussions and assignments, and then getting some practical training, reading and analyzing cases.
Because our goal is to get a basic understanding of some of these foundational concepts, we should start with a definition. So the law is a body of rules of action or conduct prescribed by controlling authority and having binding legal force. That which must be obeyed and followed by citizens is subject to sanctions or legal consequence is a law. Laws can be unwritten rules, they can be law code, we can see the law coming from case law or opinions. There are various ways that the law exists in our society. The law serves many purposes for a nation, and some legal systems serve these purposes better than others. In the United States, legislators, judges, administrative agencies, governors, and presidents make the law. We are guided in this lawmaking by our constitutions and other guidelines, but we should note that lobbyists and other policy influencers also guide the making of laws.
words mean. There is a classification between primary sources of law and secondary sources of law. Primary sources are the law, right? They are the content, they come from these governmental institutions, and we are bound by them. Secondary sources of law are books, articles, and further clarifications of the law, sometimes summarizations of the law. So there are things like legal encyclopedias. One very common legal encyclopedia is Witkin. That's a California legal encyclopedia. Think about a legal encyclopedia like you would anything else. If you are looking up the word robbery in a legal encyclopedia, it will be treated the same as if you are looking up caterpillars in a regular encyclopedia. It'll give you some background information. Treatises are in-depth encyclopedias that really focus on one subject matter, so maybe the criminal law. Law review articles are publications that are reviewed by law students, but they are published and written typically by legal scholars or professors. And compilations of law is sort of the bringing together of the general rule, and restatement is kind of the biggest compilation of law. So all of these are secondary sources because they're really summaries and explanations, sometimes even argument or criticism of primary sources. So as we discussed earlier, case law being one of the primary sources of law means that there has to be a body of law that comes out of these court decisions. And as we saw from the English common law, where they had a body of this law that came from court decisions, we have also adopted this system. And the way that we can ensure that our common law system works is through this concept of stare decisis. Stare decisis literally means to stand on decided cases. But what it actually tells us is that through the common law, through these court decisions, judges have to follow precedents that are established in prior decisions in their jurisdiction. A precedent is just a past decision that holds some sort of legal principle as true. So, courts in California are bound by prior decisions made in California, especially those made in the higher courts in California. But courts in New York are not bound by courts' decisions in California. So the jurisdiction or the state in which the decision takes place has a big role in stare decisis. Stare decisis really has two aspects. The first is that a court should not overturn its own precedents. Although this happens on occasion, for the most part, in order to ensure this stability in our process and predictability in our legal process, courts are going to be bound by prior decisions. The other aspect of stare decisis is that decisions made by a higher court are binding on lower courts. We're going to talk about the structure of our court system in the next chapter, but for now we should note that there is a hierarchy of courts in every jurisdiction, And stare decisis is really a trickle-down process. So the highest court in the jurisdiction makes a decision, it's going to bind the rest of the courts in that jurisdiction. Make sure you also take a look at the page in your Canvas module that has a video about stare decisis for some extra explanation. We're going to do a little stare decisis of our own, and you're going to think through this on your own and come up with your own decision. So what should happen to student A if student A is caught cheating on a test when student B, who was caught cheating several days earlier, is expelled? So student A caught cheating, student B several days earlier was expelled. Well, by precedent, student A should also be expelled, right? If we're saying this was a past decision that is binding on our quote-unquote jurisdiction, then we would follow that precedent and student A would receive the same consequence. Now let's change the facts slightly and see if you come up with the same answer. So we have student A caught cheating on a test when student B, who was caught cheating several days earlier, is expelled. But what if student B had previously been warned against cheating, but student A had never had any warnings? So student B receives a warning, then caught cheating again, is expelled. Student A has never received a warning. Does that change your answer? Would we still expel student A, or does that varying of the facts change how you might come out on the result? Now, it may not. For some of us, we may feel that if that's the rule, then student B should also be expelled. But I think a lot of us would feel, okay, well, if there was a precedent set that a warning needs to be given, then another warning should be given to this student who was also caught cheating. Varying the facts, we can see how judges decide cases and how different facts or distinguishing facts may change one case to the next, and it may affect the outcome of how a judge can rule. As we finish up chapter 1, let's make sure that we understand these terms here because they're going to be coming up throughout the entirety of this course. So plaintiff or petitioner is the party who initiates the lawsuit. Defendant or respondent is the party against whom the lawsuit is brought. So if plaintiff sues defendant, right? Plaintiff initiates, defendant then has to defend against it. For the appellate system, appellant is the party who takes the appeal from one court to another, and the appellee is the person who has to respond to that appeal. The difference, right, between those trial courts and appellate courts is also going to be brought into play here because the appellant or the loser of the trial court is going to appeal up to that appeals court. Make sure that you also take a look at the page discussing analyzing cases. There's also a bit on stare decisis. Take a look at that in your Canvas module as well.